जस्टिस माहेश्वरी अपना फैसला पढ़ रहे हैं और अब तीसरे जज अपना फैसला पढ़ रहे हैं। ऐसा
in any manner cause damage to the basic structure of the Constitution of India. C. Reservation for economically weaker sections of citizens up to 10% in addition to the existing reservations does not result in violation of any essential feature of the Constitution of India and does not cause any damage to the basic structure of the Constitution of India on account of breach of the ceiling limit of 50% because that ceiling limit itself is not inflexible and in any case applies only to the reservations envisaged by Articles 15.4, 15.5 and 16.4 of the Constitution of India. Not much of the contentions have been urged in relation to the impact of the amendment in question on admissions to private unaided institutions. However, it could at once be clarified that what has been observed here and above in relation to the principal part of challenge to the amendment in question, read with the decision of this court in Pramati Trust, the answer to the issue framed in that regard would also be against the challenge. Accordingly, and in view of the above, the answers to the issues formulated in these matters are as follows. 1. The 103rd Constitution Amendment cannot be said to breach the basic structure of the Constitution by permitting the state to make special provisions, including reservation, based on economic criteria. 2. The 103rd Constitution Amendment cannot be said to breach the basic structure of the Constitution by permitting the state to make special provisions in relation to the admission to private unaided institutions. 3. The 103rd Constitution Amendment cannot be said to breach the basic structure of the Constitution in excluding the SEBCs, OBCs, SCs, SPs from the scope of EWS Reservation. Consequently, the transferred cases, transfer petitions, read petitions, and the petition for special leave appeal forming the part of this batch of matters are dismissed. Our acknowledgements while closing on this reference, sincere thanks and compliments deserve to be placed on record for the learned counsel for the respective parties, their associates and their researchers, and also all the constructive contributors whose erudite and scholarly presentation of respective viewpoints has rendered invaluable assistance to this court in shaping the formulations herein. Thank you.
I'll now invite Honorable Justice Bela Trivedi to place her view.
I have concurred with the opinion of Brother Justice Maheshwari. However, have penned down certain my views also. I'll just read them out. As well settled, it must be presumed that the legislature understands and appreciates the needs of its own people. Its laws are directed to the problems made manifest by experience, and its discriminations are based on adequate norms. Therefore, the constitutional amendment could not be struck down as discriminatory if the state of facts are reasonably conceived to justify it. In the instant case, the legislature, being aware of the exclusion of economically weaker section of the citizens from having the benefit of reservations provided to the SCs, STs, and SCBCs citizens in Clause 4 and 5 of Article 15 and Clause 4 of Article 16, has come out with the impugned amendment empowering the state to make special provisions for the advancement of EWS other than the classes mentioned in Clause 4 and 5 of 15 and Clause 4 of Article 16. The impugned amendment enabling the state to make special provisions for EWS of citizens other than SCs, STs, and SCBCs is required to be treated as an affirmative action on the part of the Parliament for the benefit of and for the advancement of the EWS of the citizens. Treating EWS of citizens as a separate class would be a reasonable classification and could not be termed as unreasonable or unjustifiable classification, much less a betrayal of basic feature or violative of Article 14. As laid down by this court, just as equals cannot be treated as unequals, unequals also cannot be treated as treated equally. Treating unequals as equals would be as well offend the doctrine of equality enshrined in Article 14 and 16 of the Constitution. The SCs, STs, and backward class for whom the special provisions have already been provided in Article 14, 15.4, 15.5, and 16.4 form a separate category as distinguished from the general or unreserved category. They cannot be treated at par with the citizens belonging to the general or unreserved category. The impugn amendment creates a separate class of EWS from the general or unreserved class without affecting the special rights of reservations provided to the SCs, STs, and SEBCs. Therefore, their exclusion from the newly created class for the benefit of EWS in the impugn amendment cannot be said to be discriminatory or violative of Equality Code. Such amendment could certainly not be termed as shocking, unconscionable, or unscrupulous travesty of quintessence of equal justice as sought to be submitted by learned counsels for the petitioners. The sum and substance is that the limitations, that is substantive or procedural, imposed on the exercise of constituent power of the state under Article 368 could not be said by any stretch of imagination to have been disregarded by the Parliament. Neither the procedural limitation, that is the mode of exercise of amending power, has been disregarded, nor substantive limitation, that is the restricted field, has been disregarded, which otherwise would invalidate the impugned amendment. What is visualized in the preamble and what is permissible, both in Part 3 and Part 4 of the Constitution, could not be said to be violative of the basic structure or basic feature of the Constitution. In absence of any obliteration of any of the constitutional provisions and in absence of any alteration or destruction in the existing structure of Equality Code or the basic structure of the Constitution, neither the width test nor the identity test as propounded in Keshwanan could be said to have been violated in the impugn amendment. Accordingly, the challenge to the constitutional validity of 103rd Amendment fails and the validity thereof is upheld. And before parting, I have expressed my views on the time span to be prescribed for the reservation policy. I have quoted the observations made by the Constitution Bench in K.C. Vasant Kumar, observations of Justice D.A. Desai, Justice Venkatramaiah, Justice Chandrachud as he then was, and also in case of Ashok Kumar. And then I said, what was envisioned by the framers of the Constitution, what was proposed by the Constitution Bench in 1985, and what was sought to be achieved on the completion of 50 years of the advent of the Constitution, that is, the policy of reservation must have a time span, has still not been achieved even till this day, that is, till the completion of 75 years of our independence. It cannot be again said that the age-old caste system in India was responsible for the origination of this reservation system in the country. It was introduced to correct the historical injustice faced by the persons belonging to the SCs, STs, and other backward classes, and to provide them a level playing field to compete with the persons belonging to the forward classes. However, at the end of 75 years of our independence, we need to revisit the system of reservation in the larger interest of the society as a whole, as a step forward towards the transformative constitutionalism. Be it noted that as per Article 334 of the Constitution, the provisions of Constitution relating to the reservation of seats for SCs and STs in the House of People and in the legislative assemblies of the states would cease to have effect on the expiration of the period of 80 years from the commencement of the Constitution. The representation of Anglo-Indian community in the House of Parliament and in the legislative assemblies of the state by nomination has already ceased by virtue of 104th Amendment that is with effect from 25th January 2020. Therefore, similar timeline, if prescribed, for the special provisions in respect of the reservations and representations provided in Articles 15 and 16 of the Constitution, it would be a way forward leading to an egalitarian, casteless, and classless society. Thank you so much.
May I now invite Justice Paradiwala to place his view?
While concurring with my esteemed brother, Justice Maheshwari, and my esteemed sister, Justice Bila Trivedi, and while upholding the validity of the impugned amendment, I have thought fit to observe. I quote, thus, reservation is not an end, but a means to secure social and economic justice. Reservation should not be allowed to become a vested interest. Real solution, however, lies in eliminating the causes that have led to the social, educational, and economic backwardness of the weaker sections of the community. This exercise of eliminating the causes started immediately after the independence, that is almost 7 decades back, and it still continues. The long-standing development and the spread of education have resulted in tapering the gap between the classes to a considerable extent. As larger percentages of backward class members attain acceptable standards of education and employment, they should be removed from the backward categories so that the attention can be paid towards those classes which genuinely need help. In such circumstances, it is very much necessary to take into review the method of identification and the ways of determination of backward classes, and also ascertain whether the criteria adopted or applied for the classification of backward is relevant for today's conditions. The idea of Babasaheb Ambedkar was to bring social harmony by introducing reservation for only 10 years. However, it has continued past 7 decades. Reservation should not continue for an indefinite period of time so as to become a vested interest. In the result, I hold that the impugned amendment is valid and in no manner alters the basic structure of the Constitution. Thank you.
Finally, I invite Justice Ravindra Bhatt to place it.
I regret my inability to concur with the views expressed by the majority opinion on the validity of the 103rd Amendment on question number 3, since I feel, for reasons set out elaborately in the following opinion, that this court has for the first time in the seven decades of the Republic sanctioned an avowedly exclusionary and discriminatory principle. Our Constitution does not speak the language of exclusion. In my considered opinion, the amendment by the language of exclusion undermines the fabric of social justice and thereby the basic structure. I am of the opinion that the application of the doctrine of classification, differentiating the poorest segments of societies as one segment, that is the poor beneficiaries of reservation, and the other, the poorest who are subjected to additional disabilities due to caste stigmatization or social barrier-based discrimination, the latter being justifiably kept out of the new reservation benefit, is an exercise in deluding ourselves that those getting social and educational backwardness-based reservations are somehow more fortunate